Richard Fenning, Chief Executive of Control Risks, and welcome to the latest webcast today, brought to you from Washington, D.C. Our subject today is going to be cross-border investigations, and in particular we're going to be looking at the data aspects of those kind of investigations. I'm really pleased to be joined today by two eminent experts in this area. First, let me introduce David Kessler. David is a partner at the international law firm Norton Rose Fulbright. David is the co-head of their eDiscovery and information governance practice and has worked on these kind of matters both here in the United States but particularly internationally. To David's right is my colleague Jim Brooks. Jim is the CEO and president of Control Risks here in the Americas. And like David, Jim has worked on all sorts of delicate and complicated matters for our clients, both here in the Americas and globally. Cross-border investigations have always been difficult things. But in the last few years, we've seen all of our businesses go global in one form or another. We have seen increasingly complicated corporate structures put in place so that we can all leverage those opportunities to maximum advantage. And of course, we have seen this very significant increase in the amount of data, both in our everyday lives, but particularly in how we conduct business right around the world. It's a fascinating subject. There's a lot to cover. So I'm going to start with the first question, which comes to you, David. As I say, cross-border investigations have always been tricky. I think we kind of know the big picture as to why that may be. But what has changed in the last few years to make how we conduct these investigations so much more important?
Well, the fact of the matter is, for large organizations, investigations are becoming a fact of life. They're essentially inevitable because we have controls in place, we have compliance programs in place. We are monitoring to make sure that we don't have rogue bad actors that are causing issues for our company going against company policy. We've now laid on top of that a global institutions. We're trying to be in a global marketplace across multiple jurisdictions. And on top of that, we have an explosion in data. It's not just the volume of data, which are just epic in proportion, but it's also multiple channels of data. We are not just dealing with email, which is sort of everyone's buzzword. We're now dealing with text and social media. We have very complex IT environments. We have decentralized information down to individual employees so they can make good, leverage-informed business decisions. That's also made a very complicated IT infrastructure. So now we can have issues or concerns happen in multiple jurisdictions at once and have data in both those jurisdictions and in other jurisdictions. And then we layer on top of that issue, right, where we're trying to move very quickly to figure out if we have a problem because, you know, good corporate governance, good corporate citizenship, we want to root out these issues and then turn to whatever regulatory environment that we exist in and get ahead of the message, right? We want to know what these problems are. We don't want to be caught by surprise. We don't want to have a litigation spring up where we don't know it. But we find out that all the different jurisdictions we are in, which have all these incredible regulatory frameworks that we exist in, also have very complicated data protection, data secrecy laws that regulate how we hold data, how we process data, how we transfer data between jurisdictions, within even jurisdictions. And we have a lot of different actors and stakeholders in these products. So it's the employees might have specific rights, trade associations, workers' council, our customers, third-party contractors, all have different rights of their own that they're going to want to make sure aren't trampled on in our rush to figure out the truth, right? Because investigations, at the heart of the matter, investigations are about what happened, what's the meaning. Let's not get buried in the data. It's all about bubbling up the right information to get to the right person to make the right decision and potentially the right disclosure so that we can resolve this issue, put a bow on it, and move on and really, at the heart of it, make money, be a business. And so if you're looking at the world of cross-border investigations where we're all working in multiple areas at once, the data, which is where we find the truth, right, between the interview of the witnesses and looking at the documents, there's this now regulatory framework which is unique in each different jurisdiction that we have to think about, because if this is a high value, high profile investigation, right, that we might be disclosing, there's going to be scrutiny by all those different jurisdictions about how we actually implemented that investigation and what we did to get to the data.
So the magnitude of the problem has increased, but equally it sounds that our expectations of what is going to be achieved have increased. Jim, you've worked in these kind of situations in lots of different parts of the world. Does it vary by market and by sector? I mean, we're talking about a significant global expansion of our business reach. Are there particular parts of this world that are more troublesome than others?
The simple answer is yes, absolutely. I think first and foremost, companies and organizations themselves don't really understand data, or they don't understand the value that sits within the data. And so if we draw back to a simple premise, in a recent control risk survey of 316 inside and outside senior counsel, 2/3 of them said that within the next 2 years, they are going to face a complex international investigation that's going to require moving data across borders. So that is a reality. So when we go around the markets, all markets and sectors have challenges. Today, what's in the headlines? China's right up on top. The Politburo has recently started a 5-year campaign to root out corruption within the country. What has that done? It's turned 27 Chinese pharmaceutical companies and 33 international pharmaceutical companies right into the spotlight. They have huge complex data problems, and when you overlay the Chinese State Secrets Act and the challenges with dealing with data in China, it confounds it. You can look at other more Western markets. You could look at the UK, which right now is putting in place enhanced mechanisms for dealing with regulatory investigations, particularly the sanctions or the means to resolve them. So if we look at as soon as February of 2014, there's likely to be the use of deferred prosecution agreements within the UK itself. We can look at more complex business environments, such as Russia or various places around, across the African continent. Very complex and opaque in many ways that they deal with business, so data becomes complicated in those matters. Or you can look at markets that are recently on the verge of the new introduction of data regulation, data protection regulation, such as Indonesia. If you look at sectors themselves, there's no sector is immune to investigation. So, and it's swept the board, from oil and gas to manufacturing to entertainment. So I think what we have to realize is data is an asset to organizations. It's the only asset that in the main is not inventoried on a systematic basis. We don't know where it is, and we don't know what we have. And I think if we fall back on that premise, we have to pre-plan to understand how to best solve these complex investigations before we get into the middle of them.
Let me just pick up that pre-planning point. As David, I'm just going to turn to you, but as Jim mentioned, the survey that we ran with Control Risks and The Economist absolutely pointed to the fact that well-informed people anticipate that this will happen to them. Now, no organization wants to kind of anticipate and wish this upon themselves, but in your experience, how prepared are people? When we talk about investigations, we kind of immediately think of being caught up in a sudden and dramatic crisis. But I guess prudent people ought to be prepared without wanting to bring it upon themselves. They should be prepared for that it might happen. Is that the case in reality?
Well, that's really sort of two different questions. What's the current status of the average multinational large corporation, or even, the reality is even medium corporations now are global. And then what should they do to be prepared? I think that in a jurisdiction by jurisdiction basis, I think a lot of companies have become much more prepared. They've undertaken litigation preparedness, they've invested in architecture, IT architecture, compliance architecture, legal groups in order to do investigations on a jurisdictional basis. And that, that's an investment that's paid off for them. What we haven't seen, even the most sophisticated companies are just getting involved in preparing for the cross-border investigation. And the reality is, if you're going to have a compliance program and you're going to put in controls, then you have to realize you're going to pick up noise that's going to make you think that there's a problem. Now, there may not be a problem, but you need to run it to ground. So the idea of, not doing the investigation, if you're going to have the program, is not going to work for you. You're going to have investigations. Maybe they're going to be small, maybe they don't lead anywhere, but the more likely than not, you're going to find that there are rogue actors somewhere in your organization. The bigger you get, the harder it is to have consistency across the board. So what do you need to be prepared, right? So, and I'm lucky in this regard. I get to work with very sophisticated companies who are really focused on this issue right now. And I'm blessed because I get to work in a global law firm with subject matter experts on all different issues in all types of jurisdictions.
Right.
So the first thing I think I would tell a company is, what is your team going to be? Both internally and externally, you want to have a team because, as I think Jim pointed out, this is a jurisdictional focused issue. I need to have the right people in the right location who can tell me about the China state secrecy law, or the data protection law in Germany, or the banking law in Switzerland, or the emerging data protection laws in Africa or Latin America or Russia or Southeast Asia. And then I just say, okay, so I'm going to have my team, which I'm able to move forward quickly when whatever crisis occurs, but do I have the right infrastructure in place to be compliant in the ordinary course and then in the investigation? So what does that mean? So many of the laws that we're talking about have particular procedural hurdles for either the processing of data or the transfer of data, both of which are going to be implemented in any investigation, right? Because you can't just hold the data. You need to look at it, discern the meaning from it, search it, apply the right technology tools, whether it's search terms and calibration, or technology-assisted review, or ECA, or early data assessment. But can you actually do that without trampling on the rights of the various stakeholders, whether it's the Workers' Council, or the data subjects, or the government state secrecy laws? You probably have an infrastructure somewhere. If you're a company, so you might have good resources in the UK, or the United States, or Australia, but the events occurred in Indonesia or Australia. Can I move the data, which would be cheaper for me than building from scratch in whatever location? Well, have I got the right intercompany agreements? Have I made the right disclosures to the data protection agencies where I now am? Now, getting this plan in place, like any program, you have to be risk-based. You can't spend money equally across all jurisdictions. We're trying to do more with less. So we have to be reasonable and we have to be efficient about it, right? But in those jurisdictions where you're doing a lot of work, or there's a lot of risk, or there's a lot of regulatory scrutiny, that's where you want to make certain that you have the right agreements in place, that you've talked to your workers' council or your unions, that they have the right agreement in place, you've made the right disclosures. I mean, and I'm blessed because I get to work with these great experts in all these jurisdictions. We have found over and over again that even those sophisticated companies who have really worked hard, right? They've gotten data protection officers in place, they have record managers in place, they have legal and compliance. Their agreements are about the ordinary course. They're compliant because they want to move data to make money, right? But they're not thinking outside that box that if I'm going to do the investigation, I'm going to have to do something out of the ordinary course. And have I given the right notice to my workers that I'm going to do this, that I'm going to have to do surveillance? Have I given the right notice to the data protection agency that I would like to transfer the data from Europe to the US, or from Canada to Australia? Because if I'm going to do that, and I know that's my plan, but I haven't told anyone when we need to hit the ground running, because usually these are speedy events. The one thing that I think in-house counsel hate the most is when they're told they can't move forward. They can't look at the information because we got to dot our I's and cross our T's.
Right.
The time to do that is now, and you can do it now.
Exactly. So it's not something you can start doing when the sky's falling in. This is absolutely an area that requires pre-preparation and thought. Just to pick up, Jim, on a strand of that, and that strand being electronic discovery. This is a really complicated area. A lot of people find it very resource absorbing. It's very expensive. It takes a lot of time. It's just a logistically complicated, cumbersome thing. There's got to be a way that people can start to prepare themselves in how they kind of get their organizations pepped up, ready to go on the electronic discovery front. Just talk us through some of the lessons we've learned.
Yeah, absolutely. So first, I think it's important to understand that in any cross-border situation, multiple jurisdictions, conflicting data protection laws, it's a complex and it's a situation that we need to sit back from and make decisions in advance so we can have an investigative plan going forward. So as we look at that, the first challenge is always, as David's alluded to, the complex, oftentimes in conflict with each other, and not always logical data protection regulations that aren't just between countries, but could vary by state within a country themselves. So understanding the nuances and the differences in those data protection laws and how particularly not to run afoul of them is the first step in the process itself. The second is, how do we actually identify where the data is, who the custodians are within the organization, within all around the world itself, and those custodians can be mobile devices that are personally or owned by the company themselves. It can be computers, it's servers, it's backup data centers, so data is everywhere, it's omnipresent. So understanding who the custodians are. And the third element is, how do we access that data in a forensically sound manner that's going to ultimately allow it to be an aid, a tool, and usable within the investigation itself. And then finally, as we draw down from there, it's the data itself. A lot of different data formats, sitting in different geographies, sitting in different language itself. So how do we effectively and efficiently search, process, and review that data with minimal manual intervention itself, so that we can make the decisions on that data necessary to conclude what David said. How do we get the answers that we need? It all sits within the data somewhere, so we've got to go through that process. And if I just expand on a couple of David's other points, I think you've got to make sure that whoever you're partnering with, who's ever working with you, has both the physical, but also importantly, the logical infrastructure to deal with the requirements of the investigation itself. Take, for example, an investigation where you have data sitting in three or more different jurisdictions, and you have a single review team. Do you have an application that has the ability to seamlessly integrate that data and review it across different data centers around the world and make the decisions necessary? The second element is, whenever you're dealing with technology, people are going to become very important. So do you have a project management team that understands the global complications of dealing with data right around the world, understands the local business norms, and is responsive to the needs of the client, the needs of people making decisions and using that information itself in a timely and efficient manner? The last thing you want is a whole host of people sitting on the shelf waiting to make decisions on that data, but they can't get access to it. It's the worst thing you could possibly have.
Very frustrating for everybody, right?
And then, of course, we've got to understand the cultural realities of all the areas where that data lives. So we got to remember that data just isn't an asset that you pick up and move, but data is something that lives at that intersection of human behaviors and the electronic and physical reality of that data. So we've got to understand the cultural norms to collect it in a sound manner, to preserve it and make sure we have it ultimately to make the decisions on.
David, just picking up on that point, you've touched on the different regulatory environments. People often talk about the European Union, for instance, as if it's a homogeneous unit. Just talk us through just kind of how complicated that can be and how other regulatory environments will shape and warp how these kind of investigations move forward.
You're actually absolutely right. I mean, it's amazing to me when people say, well, what do I do in the EU? I find that, like, no one asks me, well, what do you do in the United States on human resources issues, because that's all handled state by state, and there's a very complex matrix for that. The same thing's true globally, and it's true within the EU. Each member state has implemented the data protection regulation in its own specific way. Now, there's also a bunch of other laws that apply. There's banking laws. Many of the states have very different banking laws. There's surveillance issues under the Telecommunications Act. There are labor law issues that can be implemented. So we always find that it's best to have an expert who knows the specific jurisdiction. Don't try to run this entirely from a central location, assuming that you know enough, because I know the UK, I know France, or I know UK and France, so I know Austria or Italy. That's just, I think, a mistake waiting to happen. And picking up on Jim's point, the plan is key, right? These are time-sensitive matters, but they're not matters to panic on. You need to put forth a plan about how I'm going to ingest all of this data. And data does not equate to information. There can be a lot of useless data lying about that can clog your system. And so you need to come up with both. I mean, I get to work with experts who really understand what investigation's all about, who's conducted many investigations around many different sectors on many different merits. But there's also a very specific expertise around ingesting data, parsing data, and letting the right data rise to the top. And this is crucial in cross-border investigations. A lot more data. There are a lot more laws to run afoul of, but many of those laws talk about not looking at stuff you don't need to look at. And I find that companies that panic or law firms that panic tend to put their arms as broad as they can get, bring as much to themselves as they can, and start trying to look at every single document. You can't look through every single document. That's never going to work. But also now you've looked at brought a lot of stuff that you really didn't need to look at, and you've probably run afoul of processing laws and transfer laws that you really didn't need to. So let's prioritize. Let's sift. Let's see if we can use some of the great technologies that are out there to look for signals within the data without actually looking at the documents or the email or the text messages to see, well, if this is a problem about people talking that shouldn't be talking, or are doing insider trading, or we have bribery issues, let's see who's talking to who. I can find a pattern in the data, focus in on the bad nodes, and then look at those. Not only reducing my costs, but I'm looking at the right information first so I can really assess the problem. People who dive right in tend to get lost in the data that doesn't have any meaning.
Yeah, absolutely. Jim, both of our firms, Norton Rose Fulbright and Control Risks, help our clients make cross-border acquisitions and investments. We both come at the due diligence issue from different angles. We have our checklist for what our clients need to look at. Data, where does that sit in the hierarchy of needs in terms of due diligence?
Well, let me ask, it should sit right at the very top. The reality is most companies and organizations are very comfortable entering new markets or new business relationships or standing up new legal entities or acquisitions, whatever the case might be. But they tend to focus on the due diligence as it surrounds operational due diligence or financial due diligence, the legal and regulatory framework, and the due diligence necessary around those things. Answering the questions on the political and security environment, who our agents and partners should be, but rarely does it touch the data piece as a specific element. Now, if we realize that 99% of everything created is electronic now, everything sits within the electronic realm. So the real question is how do we use that data in the due diligence process as a tool to answer all the other questions that we need? And that becomes a very powerful part of the due diligence process. So I think the answer is not very much today. It should be escalated and be the key element of the due diligence process from which all other answers fall out. Say some of the contextual things around legal and the things that actually are very relevant to that particular jurisdiction.
And just to build on that point, many of the companies we're dealing with have really focused energy on creating a good record retention framework and a good information governance structure. But when they go out and acquire a new company and want to integrate that culture into their own, that's not a high priority. And this leaves them vulnerable in sort of several different respects. All the things they have done to allow for the proper compliance with data protection regulations aren't with this new entity, and now they're part of the corporate family, and they're now out of compliance. Moreover, the in-house counsel, the in-house compliance team is used to operating in a specific way because they've dotted those I's, they've crossed those T's, they have the intercompany agreements in place to move the data when they need to, or maybe they've gone even to the next level and done binding corporate rules, but the new entity isn't in part of that because you have not made the right disclosures now in that new jurisdiction. Also, you have a culture around data governance. If you have invested in this, the whole point will be to have your decentralized employees, who are really the holders of the data, to have good data practices. But this new company may not. one of the things we see often is, and this is a major factor in investigations, is the reality is we are blurring the line between business and personal. A lot of devices are multi-use. People are doing more work, they're more mobile. They are flying all over the world. They're dealing data from home. They have to be on call 24/7. You may have, historically, as the parent company, put good controls of that. Good security controls, good networking controls, you can track your data. But now does the new entity have any of those things in place? Is all of the useful information that you've now purchased, right? This is a major asset. Is it resident on inside the firewall, or is it on the CEO's tablet or smartphone? And will that walk away when things go south with them? Or if you need to do the investigation, now getting access to that, and the laws around that mixed use are very complicated worldwide, right? If you have a BYOD device and you need to look at the text messages, because most people are committing, look, the rogue actor is smart now that realizes that maybe email's being monitored, but they're not monitoring my text messages. Well, now can I go, is the policy in place for me to say, if you work on one of our devices and do text messaging, we're allowed to look at that. We get possession of the device. That's just emerging even the most sophisticated companies, and we find it to be absent when people acquire new companies. It takes years for that tail to run off, and they never do the integration completely. And then they're left holding the bag when the investigation comes.
This is very interesting stuff. We're going to come back to that theme, I think, in a moment. But whilst we've been having our discussion and ahead of this broadcast, we've been inundated with questions from people who either asking questions just now in real time or have sent them in ahead of our discussion. So, gentlemen, it's exam time. I'm going to start giving you some questions, not the easy ones from me. These are coming from real people. There's one consistent theme, actually, before we come on to some specific ones. There's one consistent theme, or one common theme, I should say, and that's about subsidiaries and joint ventures. Our conversation to now has been kind of anticipating that we're dealing with companies as kind of singular entities, but companies aren't formed like that anymore, and as we talked at the head of our conversation, in order to maximize the leverage in different parts of the world, we form ourselves in these ever more elaborate corporate structures, of which joint ventures and different kinds of shared entities are very much now the sort of common way of doing things. But this must make it even more complicated, David, and that's a big question running through a lot of our participants today.
Well, let's think about the classic cross-border investigation. You have a parent company who's very interested in rooting out the truth. You have subsidiaries generally in multiple jurisdictions that may have been have rogue actors in them that you're trying to investigate. Who's doing the investigation? Because the parent might want to do the investigation, but it may not have actual ownership or control over the subsidiary's data, in the sense that the data protection law in that jurisdiction might say that the employee at issue, the data subject, gave its data to the subsidiary, and it's the data controller. And that entity might need to do the investigation. But depending on why the investigation is happening, is there a domestic issue? The controller, that subsidiary, may not be interested in running the investigation, but the parent company may not be able to force the issue. And so is there an alignment? Is there a conflict? And one of the things we have to be aware of when these investigations occur is, if it's an investigation and there is a rogue actor, they're going to be very interested in slowing up the investigation and blocking the investigation. And these, which may seem very hyper-technical, procedural issues, are a great tool for them to do that. And so you need to figure out how to align those interests, make sure that the data controller is involved as the investigator, that they have a legal interest in protecting. One of the problems we have with these investigations is that the whole point may be to avoid litigation, to avoid a regulatory event. But if you don't have those, you may not have the legal claim or the exception you need to actually do the search, the process, to transfer. Well, okay, so how do you align those things appropriately, and so I can go forward and do the monitoring and the review? That's why the preparation is so important. So you've dotted those I's ahead of time, so you're not caught with a frustrated in-house counsel who says, I just need to look at that person's email, but for regulatory reasons in that jurisdiction, they can't see it.
Right. Jim?
And I think when you look at these, I mean, we've got to look at the investigative plan at two sides of it. We got to look at the reality that there's going to be a different perception on who's best suited to conduct the investigation. And it's going to be a balance between having the cultural reality and business norms of the jurisdiction where the crux of the investigation's occurring, with those who have the independence, are conflict-free to make the best decisions and perhaps have the resource, knowledge, and expertise to do it in a way that's probably beneficial for the investigative cause. So you got to pull those two together and work as a team, and that's the reality. You can't do it on one side or the other. It's both sides.
Absolutely. Now let's turn to some specific questions. We've got one here that's been sent in by a manufacturing company here in the United States, and a specific question about document retention policy and organized document storage. Now, this has been the sort of elephant in the room, I think, for all of our conversations, is the enormous challenge now around document retention. Jim, do you want to lead off on your thoughts on document retention?
Absolutely. So you said document retention policy. I think what we need is document retention policy and program, with the emphasis on the program.
Right.
The policy creates the corporate reality, but you got to have a program that's effective. It is the #1 protection for both sides, balancing the ability to conduct an investigation, sift through the information to come up with the relevant data and make the decision that you need to make, as well as control costs. So with 60 billion emails generated daily, and the average user...
I'm getting most of those, by the way.
And the average user having accumulating 30,000 emails a year, this is a lot of data.
Right.
So you've got to have a program that provides the governance structure. You have to have a program that provides the systems and processes to implement it throughout the organization. You've got to automate it in some way. You've got to have something that can ultimately be managed, audited, and can drive behaviors throughout the organization. It's the #1 protection an organization can have. And then second, it's got to be done in advance. When things go wrong, isn't the time to say, let's put in place a document retention policy and program, everything from 2 years ago, get rid of it. That's not the way it works.
Yeah.
So you've got to put it in place in advance. It has to be responsive to the legal and regulatory framework and statutory requirements for each type of data, and then also taking in mind what data do we need to preserve for the operations of the business itself. And that's decisions that are unique to each organization and must be answered within that organization.
And David, presumably there's a conflict between, we've already accumulated lots of data, and if we don't have this policy in place, we've got this kind of backlog of tsunami of information. How do we get that balance right between what we do in the future and what we haven't done in the past?
Well, and Jim's absolutely right. If you have the right program in place, you can start addressing this issue. No one climbs Mount Everest in one step, right? So you want to put in good practices, and it is a program. Like any compliance program, yes, the policy is the standard, but you need to teach the standard, train the standard, and then grade on the standard. If it isn't graded, let's be honest, everyone in a business has other jobs to do. Right. They make money doing other things than just managing records. And so we need to make this as easy and as simple for them as possible. And logistically, your records management function, whether it's in compliance or legal or elsewhere, needs to be able to administer it with as little friction as possible. It can't be some bureaucracy that sits on top of everything else, because then it'll have no value and nothing will change. This is really about change management. At some level, at one point in our lives, we kept everything, and now we realize we can't. It's killing IT, it's hurting legal, it's hurting compliance, and it's hurting the business because they can't find the information they want. So, I have this, what I call the bathtub of information. I've been accumulating information for years, potentially decades. I've stuffed it into all kinds of corners and cracks. I don't even know what a lot of it is. Well, you can turn your attention to that, and there are good ways to do good data disposal. Information grays out over time. That unlabeled box from 1970 probably isn't all that valuable, and the risk of disposing of it is probably pretty remote. You don't want to spend more money on disposal than you would if you actually reviewed the document. I find people tend to create very elaborate procedures. But the most important thing, you have to understand, we're on an exponential curve for data. What gets created in the next 2 years is going to dominate what was created in the last decade.
Right.
Yep.
So look at the faucet. Focus on the faucet. Make good practices now, because your bathtub will gray out. You will eventually be able to deal with that, and it'll become less valuable, less risky, less costly for you. If you keep getting inundated with data, you'll never get ahead of the curve. You have to be proactive about this.
And I think there's two sides of data as well. So there is the unstructured data, so user-generated content. But a lot of people also forget about the structured data. So those things that are fed into the databases that we use to make management information decisions within our business itself. And then just on the data itself, people tend to hoard data. It's a prized asset. So building a program comes across the basic human behaviors of, no, this is my data, you can't take it away from me. And that's really got to be managed for it to be an effective program.
And if you're going to incentivize exactly that, try to get away from the hoarding activity, you have to realize that the incentives are skewed for each individual employee. They see a lot of value in their data, and the cost of handling that data is externalized to the company. And so they don't see the actual cost of the fact that they have,
There's
gigabytes.
no pain point for them.
That's exactly right. But they see, oh, I'll be the hero because my supervisor is going to say to me, oh, I get that email from 2 years ago? Aha, here it is. Right? Oh, I'm the hero. That kind of just-in-case retention is the thing that the company needs to address. It needs to, and that has to start from the top. They have to see that value is not a value we want to share inside the community. That being said, then the people say, well, wait a minute, I can't do any of this because I got dozens of litigations, investigations going on. I'm never going to be free, so I can't really do this. Well, you can do it. You just have to be careful that you don't violate your preservation obligations and your regulatory obligations. But even in that complex environment, this is a program that can be done as long as you take the right steps and don't try to do it all at once.
Right. So we're going to take maybe another 2 questions. And David, I think you're going to have to sharpen your pencil here and go back to law school for a moment, because this is one from a manufacturing company that's dialed in from the Netherlands. And this is about EU privacy law. So does EU privacy law apply if the case or the investigation is based outside the European Union, but the data itself is being processed within?
All right, so you asked me to do this as a law school exam. So the first qualifier is I don't practice law in the Netherlands, and I'm lucky enough to have people that I have a resource that I can go to make these, to do that for me. That being said, I've done this innumerable times in the EU, and the short answer is yes, it does apply, because if the data subject's in the EU and the data's in the EU, they're going to have a specific set of requirements about how that data is going to be processed and how it can be transferred. Even if the investigation's US-centric, the reality is investigations don't have geographic boundaries. If it's relevant to what happened, the US, either the government or the civil plaintiff's going to ask for that data, but you have to do that in compliance with the various member state-specific regulations that apply. I'm lucky enough to work and be a member of the Sedona Conference. They've done a lot of work in this area, WG6. They have international discovery principles. I think they're extremely helpful in this regard to really work through those issues. I don't have time to go through all of it, but yes, I would assume they apply. The one thing I would say is if you don't secure the data and preserve it, you have to do that first and then work forward as your plan about how you're going to process and transfer.
Okay, so we've got another European Union question here, I'm afraid. Actually, it's from a telecoms company here in the United States. Obviously, a lot happening in Europe at the moment. This is about ordinary course business records that may be considered personal data in Germany, but they're wanting to export it back to the United States for the purpose of the investigation.
So, okay, so this is a classic problem we see all the time in investigations. First of all, there isn't Germany in this respect. It's a federated state. There are different laws that apply depending on where you are in Germany. So with that caveat, and I don't practice German law, the reality is in the US, we're so used to culturally that if the data exists within the company can monitor, look at it, review it, and disclose it, assuming it has the right policies in place. That's not necessarily true in Germany or elsewhere in the EU. Absolutely solid corporate records that are crucial to the memorialization of transactions absolutely can contain personally identifiable information that is protected in Germany. Personal information is very broad in the EU, and it can absolutely contain people's names, titles, email addresses, personal information that makes it identifiable to them that you have to protect. So you can absolutely run afoul in an investigation or discovery of not treating it with the respect it deserves. You need to think about how am I going to process the data, what's my excuse? Can I use a legal claim in Germany to look at it? Do I have the consent of the employee? That's troubling because the power differential between the employee and the employer. We often see that the exception that's most often used in this regard is a legitimate interest of the data controller, but that is not a carte blanche exception. You have to balance that with the rights of the data subject. There are very specific principles that are laid out in all the member state data protection laws, and the problem that make many in-house counsel feel uncomfortable, and data privacy offers both across the Atlantic and here in the United States is, am I balancing those correctly? Will ex post, when I get reviewed by the agency, will they agree that I who have obviously an interest in doing the investigation, correctly balance the rights of the data subject? And then, can I be transparent with the data subject? Maybe not. If the investigation, if they're a rogue actor, I might be afraid they're going to delete data. And there are exceptions, and it gets very convoluted, but that's generally how we see this process happen. But I think going back to Jim's point, have a plan, don't panic, and prioritize so you're not moving more data than you have to.
Sorry, Jim, just finally, we've experienced that same problem in Asia, where it's obviously different for the European Union, but there are very significant problems about exporting data back to the US or back out to other countries.
So the goal is really, how do you avoid creating secondary complications or challenges for yourself?
Yeah.
And you got to make these decisions based on the nuances of each investigation and the jurisdictions where the data resides. So if you look at China as an example, they have the State Secrecies Act. We cannot remove data physically from China without going into great complications and putting everything at risk. So the question is, do you leave the physical data in China, in this example? Do you have to review and make decisions on that data, so only look at it from within the borders of China, or can you review it from afar? And I think that's going to depend on the case, depend on the legal opinion and the advice of counsel in the case. But I think if we fall back, it comes to the investigative plan, understand the nuances and tricks, and where do you store it, where do you review it, and how do you make sure you can do it in the most effective and efficient way without running afoul of regulatory issues or creating secondary complications.
That's fantastic. I think we're going to call a halt there. We've just got through some of the questions, but that's been really informative. David, Jim, thank you very, very much. I hope that's been a useful discussion. What is clear is that we've only really scratched the surface of this very significant problem and issue that, as our business lives become ever more complicated in different parts of the world, is all set to grow. As I say, we haven't got through all of the questions. We will do our best to get back to all of you who have submitted questions, and indeed, if there are other issues that have sprung into your minds during our conversation, please don't hesitate to get in touch. But thank you very much for your participation, and it's goodbye from Washington, D.C. Thank you very much.